So I want to turn back to each of you just to see if there's any final brief remark you'd like to say to our attendees for being with us. And we'll start with Mark.
Sure. I touched on many of these points in my last answer, but so sampling, surveys, content analysis are all useful tools in litigation, can be used by both plaintiffs and defendants. But doing them right is complicated, and make sure that you are working with someone who has the right expertise. And finally, they take time. They're not something you do very quickly. So make sure that you plan early in your trial plan so that you can get any work done you need to do before it needs to be disclosed.
Excellent. Frank, any quick thoughts you'd like to share with our attendees?
Well, I certainly share Mark's thoughts. I guess the one takeaway from Tyson, Vaquero, and the My Ford litigation was really what records the defendant had in order to rebut the evidence that was being proffered by plaintiff's experts. I think in each of those cases, the defendant really was lacking in the records it maintained, and that's perhaps not unusual, but I think that it's important to determine whether in fact you as a defendant have evidence to rebut some of these claims that, for example, in the My Ford case, I think the difference was $749 or $1,300, as I recall, and Ford didn't maintain any type of data as to what, in fact, that additional feature cost or added to the price of a vehicle. And similarly, in Tyson, we know that there was no records as to the amount of time being used to take off and put on the protective equipment. So it's look at the records you do have to see if you can rebut some of the evidence being offered by the plaintiff, and maybe in most cases you don't, but don't give up looking.